Hi, everybody. It's Electra Yao, artist visa lawyer located here in New York City. Thank you, everybody, for joining the live here on TikTok, on Instagram, on Facebook, and on YouTube. I'm going to be going back and forth between all of my screens to give you updates on the O-1 visa. I'll be giving you updates both on what I am seeing in my consultations and updates that I'm seeing with the cases that are getting approved and the cases that are getting RFE'd. As usual, if you have any questions, feel free to type them in the chat, and I'll try my best to get to your questions and answer them. So let's start with the consultations. What is the number one thing that I am seeing across the board with all of our consultations? So the first thing that I am seeing is clients or potential clients actually consulting really late in the game. So as most of you should know, if you have been watching my videos, the O-1 is not a sprint, right? It's not necessarily a case that you should rush, especially at like the very beginning stage. When you are thinking about your O-1 visa journey, that's the time where you should book a consultation, right when you're thinking about potentially pursuing this so that you can get information from the actual attorney, right? A lot of people, they think that, oh, the attorney will create miracles. The attorney will, file my case. Now, legal work can be completed in a very quick in a very rapid time frame, but that can only happen if you're actually going to have the data and the information to give to the attorney. So that is why when you are thinking about the O-1 visa, that is when you should consult with the attorney, because the attorney should be able to look at your petition and say, or look at your professional profile, and say, hey, you should do A, B, and C, or you haven't done enough, or this is what I'm seeing that is getting cases approved. Why don't you think about trying this? Now, it would be unreasonable to expect an attorney to be like a career coach and be able to advise you on all the different professional opportunities that exist within your field. But if the attorney is experienced enough representing that type of professional profile, then the attorney should be able to see patterns with regards to what is a successful case. Successful case meaning a case that is approved or approvable, right? So best case scenario, you're thinking about your O-1 and you're like, okay, let me book a consultation and get a professional assessment so that I don't waste my time down the line. Now, I'll give you an example of a client that I consulted with who basically had, I think, maybe 5 days left on her grace period. So in order to maximize your best chance of success, you want to have time to prepare the petition. And you also want the attorney to have time to prepare the petition. It doesn't matter how great your professional profile is. So this client in particular is a micro influencer working with very niche brands, actually really interesting and strong profile. We do micro influencers all the times. In this client's scenario, or this potential client scenario, I had to advise her to extend her I-20, so that she had more time to actually gather the information together. Because you can have a great professional profile, i.e., you can have a great portfolio. But if we do not have letters of recommendation, if we do not have future contracts that are willing to work with you, then the petition does not exist, because the petition is a composition of different elements, which includes the portfolio. Whenever I talk to clients about the case, try to think of the case as like a hamburger or a veggie patty or like a sandwich or whatever. So the inside of that burger is the meat, right? And the meat is your portfolio. But a burger wouldn't be a burger if you didn't have lettuce and tomato and the two buns. And it's the same thing with the petition. You can have a great portfolio, you can have great meat, but if there's missing certain elements within the composition of that petition, then the case cannot be filed. So unfortunately, in that person's case, because she had so little time, the best way to protect the client is to advise the client of a situation or a scenario that would allow her to extend her current status. Now, I'm not sure if this is something that you are hearing amongst your peers or amongst other people who have been applying for the O-1, but it's important to note that there was a rule that was recently changed with regards to the O-1 and other work-based petitions, such as the H-1B. And in this scenario, in this new change within the rule, if your underlying status expires plus a denial, then a notice to appear in immigration court can be issued. What does this mean? So let's say you're applying for your O-1, right? So you apply for your O-1 and your F-1 expires while your case is pending, and then your O-1 gets denied. Well, that is the recipe for being in removal proceedings or deportation proceedings. This is essentially the government saying, hey, your O-1 was denied. Plus, you don't have F-1 status. I'm going to refer you to immigration court. Now, I have not seen this with our clients, right? We have not been seeing this. We have not been getting denials. However, I do have colleagues who are seeing this, particularly for those who are in H-1B status, who are being fired by their employers or let go by their employers. They have that 60-day grace period, which is a period of authorized stay. It's not O-1 or H-1B status, and these NTAs are being issued. So you want to make sure that you are very, very cognizant of time. This is not the O-1, the H-1B. These visa types are heavily dependent on external deadlines. So the deadlines that are issued by the government, and then internal deadlines. So the deadlines established by the law firm or the attorney that you're working with in order to craft the strongest petition, right? Because as I always say to my clients, the O-1 is not just you and me, right? If it were that easy, that would be great. That'd be fantastic. But that's not the case. In the O-1 world, we need to mobilize all these different players that have a specific function within your petition. What does this mean? This means that, yes, I am preparing the legal documents, but you are connecting with the signers to be able to sign them and endorse them, which means you are dependent on their schedule. You are connecting with the agent in order to sign and endorse. Now, people have lives, right? I mean, that's just the case, especially if you're in New York or a major city. Like, people are doing different things. But just the number, I'm going to tally this off for you. It's you. It's me. It's the agent. It's the 8 signers. We're at 11. It's the at least 3 contracts. So now we're at 14. And then we have the labor union. There's a lot of people involved in your case. And you are beholden to their schedule and you're beholden to their signature. Otherwise, a case cannot be filed because these are legal documents. So the point that I'm trying to make is that if you are thinking about the O-1, that thinking should also be executed or externalized with a consultation. You do not want to be one of those people that has to extend your I-20 simply because you don't have enough time. Now, not having enough time is going to have, like I said, legal implications on you and obviously legal implications for the attorney that's filing your case because, again, this is something that the attorney has to put forward. The attorney's license is on the line. So that's the number one thing I'm seeing with consultations. People being very unsure, like, hey, should I even think about the O-1? Should I do the O-1? And then at the last minute, they decide to commit to the O-1, but there's simply not enough time to safely file the case. That's the number one thing I'm seeing. The number two thing that I am seeing is essentially people who are not really aware of the O-1, right? They know that there's an artist visa, but they're really haven't done any preliminary research, which that's fine. You don't need to do the research. It just means that it's not going to be the best use of your time when you're talking to an attorney, right? When you've paid for a consultation and you want an analysis on your professional profile, but the attorney needs to spend 10 minutes talking about what a letter of recommendation is, then that might not be a great use of your time, especially if you want to be cognizant with your funds and with your money. Now, I'm not saying you need to be prepared to have like a legal conversation with an attorney, but I think having the basics down is going to assist you in really thoughtfully engaging with the attorney to talk about what the most important thing is in a case, which is strategy. I can explain to you the law as much as you want. And I love doing it because I love O-1s. It's actually the only case that I work on. I only work on artist visas, whether O-1, P-1, or artist green cards, which is EB-1A. Those are the only cases that I do. I will occasionally do a marriage case for an existing client. So I am very, very focused on the arts. And the reason for this is because I love the arts. I have a film degree. I worked in film and TV prior to becoming an attorney. This is something that I'm very, very invested in. I collect art. I mean, this is something that I love, right? I can talk to you about the law all you want, but like I tell everybody, the law is out there, right? Lawyers are no longer gatekeepers of information. I'm not gatekeeping information. You could literally go on Chat GPT and figure out like what the regulations are, and we can talk about that. But what's going to win your case is not me talking to you about what a letter of recommendation is. It's me talking to you about the strategy of what a letter of recommendation should do to work for you to get an approval or to be construct a case that is strong enough for an approval. So thank you so much. That's why you're the best, Kinchin. Thank you so much for that comment. Like I said, having basic knowledge on what future work is, I think is important for you. Again, in a consultation, your time is limited, right? I'm not going to spend an hour with you because our consultations are not an hour. Maybe there are other lawyers that have an hour consultations, but what I want to do for you is I want to make sure that you leave the phone call with a potential strategy. Whether you use it with me or not, it's up to you, right? You should always work with who you feel comfortable with, right? Whether that's me or whether that's somebody else. But strategy is the name of the game. Strategy is what's going to get you approved. And number two, and I say this a lot, it's the devil is in the details, right? Generic information about your work or generic information about your ethos as an artist or a generic understanding of art in general, at least the art that you create, is not going to win the case, which is why our strategy sessions are really important, to be able to niche down into what it is that you actually do and what it is that makes you unique, that makes you special, that makes you different. And most importantly, that is going to fit into a narrative that is going to be easily understood by somebody who is not an attorney and not an artist. This is probably one of the most critical aspects of the O-1, which is translating all of this artistic and legal information to a non-attorney and to a non-artist, right? This is what a good attorney can do. So that's the consultation. Now, what am I seeing at the RFE stage? Now, I'm going to preface this by saying at this point in this current administration, you kind of just need to expect an RFE. And if you don't, then you're lucky. And if you are working with another attorney and you did get an RFE, it is most likely than not the fault of the attorney. It's the fault of the current climate. There are some attorneys that are not so good. There are some attorneys that are great. But for those of you who are working with O-1 attorneys, chances are the RFE is not the attorney fault. So don't go and blame the attorney. Get a second opinion if you want, but don't go and blame the attorney. What am I seeing? I'm seeing silly RFEs. I'm reading an RFE today where they are saying that we incorrectly filed the case because the petitioner is a green card holder. That's incorrect law. A petitioner can be a green card holder. A petitioner does not have to be a U.S. citizen. A petitioner does not need to be a company, right? It can be a company. It can be a U.S.-based U.S. citizen. It can be a U.S.-based green card holder. All of these things are permissible by law, right? Now, the problem with these silly RFEs is that I'm working with somebody who doesn't know what the law is. So this RFE that I'm going to have to respond to is going to basically regurgitate the law and educate the officer. These are the worst types of RFEs because it's kind of like a teacher-student relationship, but the power dynamic is off, right? I'm putting forth the petition and they have the power to deny me. So it's like they need to accept my reading, which is the black letter law reading of the law. They need to accept my reading of the law when they should already know it. It's like nonsensical. It's a very, very weird power dynamic where, unfortunately, the power dynamic is not on my side because they're the ones who make the decision. So a silly RFE as to whether or not this person can serve as the agent is a waste of the officer's time, is a waste of the government's resources by paying this individual. And most importantly, don't you want people to do their job properly? I think that's what we all want. I don't think anybody wants to waste government resources or government time. I think we all want to make sure that the government is doing its job, obviously with petitions that are very, very strongly prepared. There's some attorneys who might not prepare a strong petition, or there's some people who will file a petition without an attorney. Now, that happens, but that's neither here nor there. We're talking about petitions that I prepare in my firm, and we have a 99% approval rate and a 100% approval rate for EB1As. So I work really, really hard on our cases, and so does the rest of the team. Now, These RFEs, very silly, right? Basically ignoring the law, basically forcing us to re-argue elements of the law all over again. And like I said initially, you should just at this point expect them with the current administration. Why am I saying you should expect this with the current administration? Because number one, there were a lot of firings at the beginning of the new term. Number two, they stopped the work from home mandate. Now they forced officers to go work in the office. A lot of them were really unhappy about that, and went to go find other sources of employment. There have been new changes that have been impacting lots of people, such as the new rule with regard to third country nationals going to a consulate that is not their consulate of origin. So let me give you an example. There are certain consulates that are better for O-1s than others. I mean, this is just the name of the game. Like there's some consulates that really understand O-1s, that really understand the abstract nature of O-1s, and other consulates that I'm just going to say very plainly, literally don't follow the law. Right? They want to adjudicate the O-1, and that's not their function, nor is that the law, right? So that makes it a very negative experience for somebody who gets a denial, because when you are denied at the Department of State, at the consulate, you only have so many options to be able to salvage that petition. So it's really important that that we are aware of the climate, which has nothing to do with the relationship you have with the attorney. It's all external, and we're trying to navigate within this chaos to make sure that you have a successful experience with our firm, but also a successful result, because you want to work in the US, right? That's the whole point of filing the O-1, the ability to professionally work as an artist here in the States. So the first trend that I'm seeing is these frivolous or RFEs that are kind of like ignoring the law. The second thing that I'm seeing is massive amounts of errors, like biographical errors, like calling the client a different name, calling the one of the contracts like a different company, like. And I will say this for everyone who's watching, it has been confirmed that they are using artificial intelligence. So we in New York, I'm a New York State licensed attorney. I am practiced in New York. I cannot use artificial intelligence unless my client authorizes me to do so. So in our contract, we literally state we do not use artificial intelligence. However, they are, which sucks, guys. I'm not going to lie to you. It really sucks. It's really unfortunate that, they are reviewing petitions with AI. I'll give you a funny story about AI before I sign off. So I had a client very anxious. Basically, what client did is put all of my information in AI. So all the legal drafts that I made for her in AI, and basically AI was like, "Listen, this is not going to win the case." I mean, obviously that was wrong. Client won the case. Client wrote a great review talking about how we changed her life. So AI is not the be all end all. And if they're using AI to make a decision on your life, it's very scary, right? You wouldn't want a doctor to chat GPT your symptoms. Just like in New York State, they protect you, the client, from having the attorney use ChatGPT to do the legal research. Now, just like you don't want your attorney to use ChatGPT, you don't want your dentist to use ChatGPT, you certainly don't want an officer using ChatGPT. But unfortunately, this is happening. This is why I'm saying expect RFEs, expect these silly RFEs, because the ChatGPT and the AI, what is missing is their knowledge of trends, their knowledge of what happens in all of these attorney groups that exist, right? All these attorneys that are in contact with each other every day, talking about best practices, best solutions. ChatGPT is not privy to that information because we do not share that information with ChatGPT. We cannot. We're a part of these groups. So this is something that, again, you should be aware of, something you should be prepared for. And this is why at the get-go, when you're thinking about that O-1, you should be consulting with an attorney. And when you make the decision to move forward to the attorney, with the attorney, you need to choose somebody that has experience with O-1s. So I'm going to go live every day. I really like talking about these trends because it's so drastic, the changes that we are seeing with this new administration, unfortunately. Now, these changes don't necessarily mean that the cases are not successful. That's not what I'm saying at all. But it's important to understand the context, right? It's like kind of like when you're eating like a dish, right? Like potatoes and chicken or whatever you eat. It's important to understand what's on your plate, right? It's important to understand what the context is so that you're prepared. So thank you everybody for watching. I will see you tomorrow. Please DM me, send me questions. I'm happy to answer anything during the live. Obviously, you know I cannot give legal advice. That would be against the rules of ethics, but I'm happy to talk about any topic that I am licensed to talk about. Thank you everybody. Bye-bye.